So we have our speakers. Our first speaker is Eric Pelton. Eric is a lawyer from Virginia, right outside Washington, D.C. His specialty is helping business protect their trademark, do trademark matters such as searches, monitoring, disputes, registration, and everything to do with trademark. He has been doing this for 22 years and is a partner at Eric Pelton and Associates. He was briefly an examiner at the US Patent and Trademark Office, reviewing application for approval and objection for the government. Last year, he was a guest on the IP series where he talked on the role of trademark for SMEs. You can check out his website at ericpelton.com, where he has tons of resources in form of videos, articles, and podcasts. He's the author of Building a Bold Brand. You can get a copy on Amazon or buildingaboldbrand.com. Eric, you're welcome.
Thank you.
Our second speaker is Rita Anwiri Chinda. Rita is an intellectual property and information technology lawyer from Nigeria and was listed in the 2020 WIPR Influential Women in IP Trailblazer. She provides advisory, advocacy, and transactional legal services to a broad spectrum of local and foreign clients. She's also the chief convener of the Intellectual Property Society of Nigeria. She has cognate experience in projects concerning data protection and privacy, media law, copyright, trademarks, and patents. Rita holds a master's degree in intellectual property and information technology from the University of Derby in the UK. She's a member of the Nigerian Bar Association, Section on Business Law Committee on Arbitration and Alternative Dispute Resolution, Information and Communications Technology, and Intellectual Property, member of National Institute of Management, and an associate member of the Chartered Institutes of Arbitrators UK Nigeria branch. Rita, you're welcome.
Thank you. Thank you.
And our final speaker is Opeyemi Kolawole. Opeyemi is a PhD researcher majoring on intellectual property and trade at the University College Dublin. Opeyemi's expertise is in intellectual property and information technology law, regularly advising on acquisition and licensing of IP strategy for startups, technology transfer, privacy, and data protection. Opeyemi's typical clients are creative and innovative entrepreneurs, as his vast educational and experiential stock provides entrepreneurs with the necessary tools to protect and exploit their IP. He holds a master's degree in intellectual property and information technology law, with a primary focus on the intricacies of patents, trademarks, and digital rights in international business relationships. He is also a graduate of the University of Geneva and World Intellectual Property Organization, training on intellectual property and business development. Opeyemi, you're welcome.
Thank you very much. Thank you for having me. It's good to be here.
You're welcome. So over to you, Deji.
Thank you very much, Abigail, and welcome everybody. I hope we're going to have a lovely time here. The aim of this event is basically to have a fireside chat, if I may say so, about various things that we'll be discussing, particularly with the theme of this year, which is taking your ideas to market. So I think I'll start with Eric. Eric, welcome again. Eric, so far as an experienced IP attorney, advising small businesses, can you give us a little, brief description of what it's been like so far, your experience so far advising small businesses, particularly around issues of trademarks?
Yeah. And thanks again for having me on this great gathering to celebrate World IP Day and discuss these important issues. So I've been in this field of trademarks for about 25 years, and following a short time at the US Patent and Trademark Office as an examiner, I started my own firm in 1999. And at the time, with much fewer online resources and much more difficult to access lawyers and law firms as a result of that, I really saw the need for small businesses to have trademark protection, but not have to do it themselves. And there weren't a lot of options other than paying a big specialist law firm or a big downtown law firm that had an IP department quite a large sum of money in order to protect it. There wasn't a market that really was targeting small businesses. And so since day one, small businesses have been the vast majority of our clients, and keeps it interesting and exciting for us. And really, it's been wonderful to see over the last 20 years how the world of IP protection and trademark protection for small businesses has grown so much. And there are now so many more firms working in that space and so many more small businesses taking advantage of the important protections.
Okay, thank you very much. Thank you very much for that. Based on the theme of today, how important would you classify IP for SMEs and small businesses right now?
Extremely important. Although, of course, in starting a small business, that's the other thing I've learned in working with small businesses is not only watching hundreds or thousands of small businesses grow, and some fail, many succeed, some grow tremendously, is also growing a small business myself as a law practice. And I also happen to have the benefit of getting insight through my wife. Actually owns 2 restaurants. So we have a lot of small businesses in the family. So I see, I know firsthand the struggles when launching a business, and there's so many competing interests and expenses from, whether it's supplies, employees, finding a location, if it's a physical establishment, all of these things competing before there's even any revenue sometimes. But the intellectual property protection is, as we know, so extremely valuable. And the earlier you start the protection, the better, and the more likely you are to succeed. That's really the key point that we find. It's never enough to keep educating new businesses about those points, about the value of protecting and making sure that you're, ensuring your investments in your brand, in your business, in your products, in your services from the outset. And then the value in doing that as soon as possible, even though we know it's going to be a challenge sometimes to come up with those fees from the start. The longer you wait, the much more exposure the business has.
Having worked with the USPTO for a bit, what are the common mistakes you've seen small businesses make in relation to protection of their IP?
Yeah, there's a lot of different ways we can make mistakes. Businesses can make mistakes when it comes to protecting their IP. We touched a little bit about just whether or not to protect it and whether or not to do it at the outset. Those are obviously key decisions, but probably the most important one is, and the most significant mistake that we see all too often, is not doing a thorough search from the start. And so even if a business maybe knows that it can't afford to file to register their trademark at the beginning, there still is a tremendous value in doing a clearance search in whatever countries, whatever markets they're planning to operate in order to hopefully establish that the name is available and unique in their market, so that they will, in doing so, if they do it right, they will significantly reduce the risk of being challenged by somebody else, and they will significantly improve their odds of getting a registration approved, even if they can't file that registration right away. And of course, there are many different levels and types of searches. At the high end, there's paying counsel to do, a sophisticated clearance search and analysis and order a report from a vendor. And that is obviously important and the best one available. But at a minimum, we try to encourage businesses before they commit to a name, again, before they invest in, acquiring domain names, building signs, logos, any of those things, to at least search online on major search engines, search the US Patent and Trademark Office, maybe search the WIPO databases, other databases. Of course, all of those things can be tricky, but it's better if they do some searching than if they do none.
You touched on also, being a startup founder yourself as well, which is very good, yeah. And I think it's necessary for the kind of question I'd like to ask next. What are the things, before the theme of this year is taking your ideas to market, yeah. So what are the things SMEs should put into consideration before actually taking their product to market, based on your experience as a lawyer and also as a startup founder? So it's a unique blend for you. So we'd like to hear from you on that as well.
Yeah. Thanks for the question. And I think that maybe my perspective hopefully can help some listeners. In addition to considering the IP issues, of course, you want to look at your business plans and your what your expenses are going to be, what is necessary to get from the dream and the idea to the actual market, and how long that's going to take. Now, just because it may take a long time, doesn't mean that the intellectual property protections can't begin right away. And we should mention, of course, that if there are possibly patentable ideas, we recommend that the SMEs talk to patent counsel who's knowledgeable in their field of operations to investigate whether or not patent filings should be made. Of course, if there are copyright works being created as part of the business, to also consider all of those things. But there's a whole host of issues for businesses to consider before going to market. And perhaps a blessing and a curse of so many businesses being online right now is that in some ways it's easier than ever to start a business and get it to market in many instances. But these steps are still important. Another step that I would always recommend an SME consider and pause before actually going to market is to form a separate business entity, right, with separate bank accounts, whether it's a corporation or an LLC or a different type of entity, depending on where they're located, to have an entity to safeguard their assets and to separate it from any personal liabilities to the extent possible. And that's also another step that we find many tend to overlook or tend to think it's not as important to go through those steps at the outset. But again, it's a lot easier if it's done right from the start.
All right, then. So I'll take a pause on that. I'll jump to Rita. Rita, thank you for being with us today. I'd like to ask, basically, from your practical experience, how can SMEs take advantage of intellectual property in their business right now before they go to market or when they go to market, from your experience?
Okay, thank you so much for the opportunity and also this question. So I think one thing that business SMEs and startups and business owners need to take into consideration is the fact that from the moment they think of starting a business, they should have or start to have long-term goals. So other than drawing up business plan, what are the long-term goals for your brand? Is it supposed to be like a side hustle? Is it supposed to be like temporary business? What plans do you have? So I usually tell people there are 4 things you need to look at. You need to look at the pre-market stage, the pre-contract stage, the post-contract and the pre-market and the post-contract stage, where before you think of starting a business, you need to have the right team. The right team should be your lawyer, not just a commercial lawyer, but an IP lawyer that will guide you and tell you the right thing to do. So like Eric had mentioned, you need to do the importance of doing a thorough search when you want to do a trademark registration. You also need to consider having like a multi-layered form of IP protection for your business. So your business could own a trademark, which could be your name, logo, sign symbol, copyright if it's a literary or artistic work, inventions, you're thinking patent. And if you're into manufacturing and stuff, so you also need to look at the visual appearance of your product. So you're thinking design, right? Now, if you're going into partnership, you should also consider having like a non-disclosure agreement with the partners. Then your team as well. Who owns what at the end of the day? If you're employing people, if you have employees, who owns the work they create while they're working for you? Does it belong to the company or does it belong to you? Then you have the post-contract and post-market stage, whereby you put the product out there. Now you're more or less invited people into your own space where you don't have a control as to what happens. So if in the event that your product gets counterfeited or pirated at the end of the day, what options do you have in terms of protecting yourself? So in Nigeria, we apply the first to file principle, whereby it's who files first that gets the IP protection, especially when it comes to trademark, patent, and design. Whereas for copyright, your creative work already enjoys automatic protection from the moment the work is created. So those are the things that you need to consider as a business person before taking your product or your idea to the market. IP basically doesn't protect an idea. We have to see it in a fixed medium. It has to be something that we could see, either as a creative work or an innovative work. And when that is not seen, you can't come out to say someone has taken your intellectual property. Especially in this era of social media call-outs, where you see a lot of people just coming online to say stuff. You need to also verify whether or not the person actually owns that work in question before going ahead to advise your clients on the right. So for SMEs, having a long-term plan is very important. Having the right team, having an IP lawyer is also very important. Doing a thorough search, whether it's for copyright or trademark or patent or industrial design, doing a thorough search is very important. And if you have the goal or vision of expanding into other jurisdictions, you need to also take into consideration that you have to do an IP registration, because IP is territorial in nature, and it's only the jurisdiction where you register your work that you get to enjoy protection and legal backing.
Thank you for that. So what you just said just now brings the idea of the issue of conflicts to mind, because a lot of business owners, generally speaking, may not understand intellectual property protection as of yet. Yes, and one thing that's clear is that there is going to be conflicts. Now, among the big corporations, we see that a lot. I think it's something they're used to in terms of having fixed budgets for chasing legal disputes in court and all. But no, so far, what kind of conflicts have you found or have you seen in your line of work that small businesses always encounter or go through?
So last year I got a call from a friend saying she had this friend who had a business and she found out that another business had the same name. So issues as to likelihood of confusion in relation to trademark, where two businesses own the same name and also in the same line of business, it kind of causes confusion amongst your consumers, because trademark as an IP is a source identifier. Then you have issues on the visual appearance of the product. So I know earlier this year we had the Danfo bag dispute where someone had reached out to the original designer and she had refused the proposal he had given, and he went ahead to reproduce the bag in question. So that can also happen where if two people want to go into a business and you don't bring the right proposal, one person might think that the fact that he has told you about it means he can still go ahead to do it. One thing that we need to know about IP is that IP's content permission or authorization is very important in IP. If you don't have any of this, you don't have the CPA, you don't have the right to go ahead to reproduce or make or sell or distribute any IP owner's content or invention or work. When you do that, you are basically infringing on the person's idea or work. So another issue is when you have a license to either create a franchise or something, and you go ahead to sub-license to a third party without the licensor's permission. Those issues also arise. Then you have employment issues where an employee creates a work while he's with his employer, and the employer decides to use the work, and the employee comes and say that's my work. So there are two ways to go about it. Under the copyright law, it states that if there's no contract stating who owns the ownership, the employee owns the work. If there's a contract and it states that in the course of your work there, the employer has the right to whatever content you create. Same thing with our design act. It also states there that if there's no contract binding the two parties. The work belongs to the employer. So you have contractual issues or employment issues. Then you also have issues of work for hire, especially for software developers or designers, illustrators. You've been hired to do something and there's no official document. And then you go ahead to say the person has infringed on your work or the person owns your work. So I know last year during the pandemic, we had the living in bondage case where the designer had said she was contract was terminated, and in all of these conversations, never a formal and itself. Luckily for her, social media collabs worked out for her and she got paid. There's some people that are very unlucky, they never get paid and they never get acknowledged or credited. So your contract determines what happens and who owns the work. If you don't to transfer all the rights to the person that hired you to do the work in question. So those are some of the issues that I've come across. Then you also
Hi, Rita.
when they sign a contract, one of the
Hi, Rita. I think you're having network issues. Yeah, yeah.
The contract and do a different thing. So I think these are like the very few ones. Life is and personal cases. So then there seems
I guess our network is off currently. But yeah, we do understand what she's talking about in terms of the issues the conflicts that arise in small businesses in relation to intellectual property. So, but I'm gonna go over to you. I understand that you do a lot of study of trade and global trade and how it links with intellectual property. Yes, no. So from your understanding, how do the forces of the global trade forces basically affect intellectual property as it relates to particularly African businesses, and what exactly have you seen so far in that respect?
Thank you for having me. So basically, when multinationals, for example, when let's say Pfizer, when you want to build a new manufacturing plant, or when you want to build a new manufacturing plant in a new location, what you're looking for are what's it called? It's called the location advantages. So you're looking at, what do I tend to gain in this new location? Will my intellectual property rights be protected? Will I be able to enforce my intellectual property? How long or what will it take for me to enforce my intellectual property in this location? So that will inform my decision whether to transfer my technology to your location or to not do so. So when we are thinking about acquiring technologies from different parts of the world, what multinationals are looking for is your intellectual property, because your intellectual property guarantees the security of your business. Without intellectual property, the encouragement to actually innovate, the incentive to actually put in money into research and development, because research and development actually cost a lot of money, like thinking about things, thinking ideation is very, very simple. Like the way we are today, for the one of us, like we can think about numerous things, but to transfer our ideas into concrete things, into concrete products, you need investment. So when you put your money into creating a product, you expect that the state or the government would step in and ensure that they offer some form of protection, some form of guarantee that your rights will be protected, that your right, once it's protected, you can actually go into the market and enforce your rights. You can enforce your right by using the intellectual property. That means you can sell your, what's it called? You can sell the intellectual property, you can license it, you can do whatever it is you want with it. But without the protection of intellectual property, trade, it's not going to happen. Trade and technology is not going to happen. If you look at UNCTAD came up with a report. UNCTAD came up with a report on innovation and technological development in Africa. And like you see the gap between Africa and the rest of the world. Like the preparedness of Africa to actually use the top 10 emerging technologies coming in the next 50 years is actually low compared to Asia, like or America or Europe. So there's a lot of things to do with our intellectual property framework in Africa to actually attract trade. And even if you look at the trade cycles in coming into Africa, you see that the kind of from foreign direct investment we get are not actually concentrated in IP dominated areas. So foreign direct investment coming into Africa usually domiciled in the extractive sectors in petroleum, in mining and whatnot. And that is not a good, that's not a good outlook for Africa. So the meaning of that is we need to look into ourselves, we need to look into our legal framework. What can we do to actually guarantee or give a form of guarantee to foreign investors that we are actually ready to attract their technology. It's not about foreigners alone. Even within our domestic our domestic system, we need to give entrepreneurs and innovators that guarantee, that assurance that once you create something useful, because intellectual property is like it's like there's a form of trade-off between the state and the private person. The private person invests his time and his property in creating something nice for the public. The public guarantees his ability to recoup some form of remuneration or some kind of financial incentives from doing that. So domestic innovators and individuals must be able to understand, must be able to see that the state is actually ready to protect their interests. And that would drive up, like even when you look at Nigeria's trade, what's it called? Our trade numbers, you see that the top 10 products we export, we don't do so much of manufacturing, for example, so we don't produce IP sensitive goods. The top products that we produce are basically our petroleums, our food crops and things like that. So to paint or to create a Nigeria, a Nigeria of the future, a more prosperous Nigeria, we have to invest more in building our IP infrastructure. And that goes down to protecting the right, like revamping our patent law, our trademarks, our copyright act, and also looking at how maybe establishing a separate intellectual property was a dispute resolution or court system just to speed up, the period between the speed up the time frame of adjudicating on IP cases. A state that is, or a country that is, interested in building for the future, not for the past, not for petroleum and what, we should be able to like invest more in our IP infrastructure.
All right, thank you very much for that. Thank you. I believe you have a short presentation, in respect of the IP architecture within Africa, our legislative frameworks, and also how IP plays with the after that's currently been implemented. So you could probably go on and share that now, give us a little insight on that as well.
Okay. How do you share your screen? Can you see my screen, please?
Yes, we can. You could go
Okay.
on.
Yeah, so basically, like I was so to speak on IP framework, the EFCT, and medium and small enterprises. So, like SMEs are like they are the most important form of enterprises you have. The bigger ones are important, but these SMEs actually feed the bigger ones. So startup and medium enterprise, they're very, very significant in the structure of the global economic system. So I was very, very pleased to see that 95% of the enterprises in the global system are like actually SMEs. And in Africa, for example, 80% of our enterprises, like they are SMEs. So we're talking about your startups, your anything apart from big multinationals. Like, and in Africa too, they're actually responsible for 80% of our region's employment. So, like for the African system, for the African region, SMEs are like very, very important to our present, and they're very, very significant to building the future that we want. So protecting SMEs business is actually protecting Africa's interest, is protecting or securing the kind of future we want for Africa. And how do SMEs? SMEs are like the way I like to see them. They are like the first step to building something, significant, to building significant or big things. Because SMEs actually go into the market. It's you and I thinking about new solutions to things and creating new products and actually trying to build on new things. And the only way SMEs can be incentivized to actually continue to invest in new products is to give them the guarantee that once you put your money, once you put your time into this endeavor, that we will be able to protect you, that the law is there, the legal infrastructure is there to ensure that you're right. Nobody copies your right. Because this example I like to give to describe IP protection. So it's if I am creating something and putting all my money, putting all my life savings into creating something, and you can create, but you decide not to create, and you wait for me to create something, to invest all my money, and what you do is just to copy it. Just once I get a nice product, you copy it and you start selling. The implication is that I will no longer be incentivized to actually invest my time or anything in creating anything useful, because I'll be waiting for the next person to actually build something so I can copy. But the problem is the next person is actually waiting for me to actually build something and copy. So we now have a society where everybody is waiting for somebody to build something so that they can copy. The implication is the society will not move forward because at the end of the day, nobody is going to build anything, and we're just going to be looking at ourselves. So the law steps into the fray to say that, yeah, like instead of having that kind of society, what can we do is to ensure that, we give you some form of incentive, knowing that when you put in your money, when you put in your resources, you will be properly, remunerated, or you'll be able to like capture the economic returns and moral returns of your investment. So IP is very, very intriguing. It's very, very important to SMEs. And without that incentive, it's difficult for private persons, because then I can always use my money to do some other things. Instead of investing in building a next generation solution to artificial intelligence, I can actually use my money and support Arsenal or do some other things. So without that intellectual property framework, then it's actually difficult for us to build the society we want. So IP leads to product development, and then it's also very, very important to capture the market, because without the IP, without your trademark, and without something to distinguish you in the market, then you probably have no footprint in the market. So IP is very, very useful. It's useful, and then it allows you to use your exclusive use of your property. You can sell the IP, you can license it, you can do whatever you want with it. Just look at your intellectual property as like your car, for example. It's like, just look at it as a valuable property you have. So the law is there to ensure that nobody takes that from you. The law is there to ensure that only yourself can drive your IP. You're the only one that can use the IP to, you can use it as security for loans. You can use it any way you wish. You can sell it, you can license it, you can do whatever you want with it. But the principle is still there, that the IP is a guarantee that the law stands behind you to ensure that your interests are protected in the market. But like IP is inherently like territorial. The meaning of that, and I think what's it called? Rita touched on it earlier. The meaning of that is IP laws are specifically restricted to each jurisdiction. So the IP law you have in the United States is different from the IP law you have in Nigeria. The implication of that is, if you have protection in Nigeria, your protection does not extend to the next country. So if you want to seek protection in the next country, then you have to go into their laws and ask them for protection. So you're only protected in a country where you've asked for protection. So your protection in country A does not extend to country B. So in Africa, for example, we have 54 or 55 countries in Africa. What's it called? 54, 55 sovereign countries in Africa. The implication of that is, as big as Africa is, then we have different laws in different jurisdictions. So, and the laws, and it's even much more complicated in Africa, because African countries are different levels of development. So you have different needs and different objectives. The objective of Nigeria, which is like a developing country, a low-income developing country, middle to low-income developing country, is different from the interest of Uganda, which is like a least developed country. So your development interest most of the time will shape the kind of obligations you have, or the kind of intellectual property framework you have. So for example, national legislations are usually crafted around international laws, like the TRIPS agreement, for example, which the TRIPS agreement offers the minimum standard of IP protection that most countries will have. Most of African countries are WTO countries, so that the basic law they have are like crafted with the TRIPS agreement in mind. But the TRIPS agreement actually offers some kind of exceptions for least developed countries. So there are some obligations that some least developed countries cannot take advantage of. There are some obligations that they are not bound to use. So it means that there are some IP laws in Africa that are like on this level, and there are some on this level. So, and also we also have some regional laws too, some ORP and ARIPO. There are different kind of laws in Africa. And the meaning of that is the African legal framework for intellectual property is actually fragmented. And that brings a problem for a small and medium scale enterprise. Because what you want to do is that you want to be able to sell your property, you want to be able to sell your product in Nigeria, and you also want to be able to sell it in Ghana. So selling it in Nigeria, you can approach the Nigerian patent office and get your protection there. But then selling your product in Ghana will also require you to go to Ghana and actually look out for go to the patent office and then do searches and do whatever is necessary to get protection there. And we have 55 countries in Africa with different kind of with different kind of laws, with different kind of administrative expectation. And how do you now expect your small and medium scale enterprise with limited budget and limited personnel and to actually scale all these orders just to like get their product out of their product out of to the market? So it can make it very, very like expensive, like an expensive process. And then you'll be able to like, because you're not comfortable with two problem, which is like the cost of it and the regulation. How do you predict the regulation? So you cannot predict the regulations that, and African countries are very they like to do, you can never tell what you get, jigger. So, and you, especially for in Nigeria, for example, everything is vibes. You can't actually know what you're going to get. So it's difficult to predict the landscape. It's difficult to actually identify what you need to do and how to plan your business in the long term. And for most of us, that we do not have just like a national orientation for what we want our business to be. We want to take over the continent. We want to sell our product in different parts of the continent. So that is where, so in order for us to like open, and the AFCTA, the idea of the AFCTA, so in order for us to like open our businesses, our small and medium scale enterprises to other parts of Africa, the AFCTA is important. Is in regards to this project. So the idea of the FCTA itself, is a trade agreement. The purpose is to, we have 54 countries in the world, in Africa. The purpose is to break down the walls, is to break down the barriers in all these countries, is to collapse the entire continent into what's it called, a big market. It's not a single, a big market where products can move freely, although there's some exceptions, and there's some negotiated exceptions to that. And so it's basically to reduce tariffs, to reduce the barriers of products permeating different borders. So, but then to achieve the aim of the AFCTA, to ensure that products move freely, you have to harmonize the laws. Like it's difficult. It will be a very, very, very difficult task to tell me, as an entrepreneur, that I can sell my product in Ghana or in Central African Republic, knowing fully well that I might not be able to get the kind of protection I want in Central African Republic. So we have a situation where if we do not align the laws, or if we do not create a comparable or legal framework for IP protection, the idea of moving goods and services across borders is defeated from the get-go. So that is where for the AFCTA to facilitate the economic growth that it wants, and to encourage the domestic innovation, it's very, very important to bring in, to align those intellectual property framework as much as possible. And then if you look at article like, of course, the drafters of the FCTA, they are aware of this, and that's why Article 4 of the AFCTA and Article 4 of the AFCTA said that like it's important to cooperate on investment, IP, and competition issues, because these issues are interrelated. They are interrelated. So, and the IP protocol, Article 8 of the AFCTA also incorporates the IP protocol into the FCTA agreement. But the IP protocol, as it stands now, is still under negotiations, and then we do not have the final text so that to analyze. So, but the potential in the IP protocol is its ability to actually ensure that there's some form of alignment, to create like to speak with a common voice of the norms and the intention, what African countries what we want to achieve. So what it will do is to enumerate, is to state some common norms that individual, that different African countries that can guide their policy, that can guide their policies. So the way I want to see the IP protocol is like, this is the first time the African region would have the opportunity to actually carve its own intellectual property rights framework. And it gives it the opportunity to look into the continent and say, what do we want? What is right for our people? The IP laws we have now were basically handed down by our colonial masters, and then most of the time they have been framed by Westerners. But the IP protocol gives us the first chance to actually look into what is important for our people, what kind of laws, what kind of protection should we offer our people? What extra layer of protection should we offer to our people? And another thing the IP protocol would do is to actually state specifically that because there are some exceptions in the TRIPS agreement, for example, that African countries have not been able to understand or implement. But what the IP protocol can do is to simplify all these exceptions and to ensure that African countries incorporate these exceptions into their domestic framework. So the IP protocol of the FCTA is a very, very important part that it's a chance that we cannot forgo, we cannot miss it, we cannot get it wrong. So it's like the ground zero. It's like a point where we now define what we want to do with our future. We can reimagine the Africa we want. And it would need to provide like the tools, the necessary tools, directed at the kind of innovation, the innovation system we have in Africa. It will be directed to address the kind of innovations we have in Africa. It will tackle the issue of traditional knowledge, for example. So plant varieties, agriculture also, like innovation surrounding agriculture also. It will address those kind of issues. But the most important thing that I think the IP protocol would do is to form some kind of harmonize the fragmented framework, is to get ORP, to get our report, to get everybody together and say that, okay, this is what we want. And there's work going on in that area. If you is PIPO. There's work going on in that area through PIPO. PIPO is Pan-African Intellectual Property Office, which is like an AU organ, and its intention is to harmonize. When you talk about harmonize, it's not trying to unite. It's not trying to create a central IP framework for the entire African continent. What it's trying to do is to ensure that what ORP is doing, what different organizations, what different patent offices, what they are doing, they actually align with the common African goal, with what we want to achieve as a continent. That is what PIPO is, and that is what PIPO is doing. So, like I said before, we have different frameworks going on, different IP laws or different things going on. So the IP protocol gives us a chance to actually come together and say that, to have a common ground on this is what we want. This is the direction we want to go. But remember in the Nigerian context, because I was trying to relate it to the Nigerian context and the SMEs we have in Africa, like most of the problems we have is the AFTA would not replace the space of domestic policy making. Like I said, it gives us like an endpoint, a guide to what is expected, to what Africa expects. So the point is still there for the Nigerian policymakers to look into how can we structure our intellectual property rights framework to actually encourage innovation. So nobody's going to South Africa is not going to come and do that for Nigeria. And I think that one of the things that, because SMEs are, I would like to think of them as, they are not the richest, or what's it called? They're not the richest organizations. Because when I look into our RIPO and OAPI, you see that they have the utility patents going on there. That's utility patents is like when you make small and incremental changes on a known invention, and then you just apply for a patent just to protect that, like making an alteration to a known device. So it's not as broad-based as a normal patent, but those are the kind of petty patents that it was very, very instrumental in the development of Japan, for example. So if Nigerian laws can actually introduce this kind of utility patents, then it will go a long way in helping SMEs actually protect their work. So, and most of the time, the protection is usually between 6 to 10 years. So, but within that time, you as an SME, you should be able to develop more, like if it was a petty patent before, but you can develop the product and actually have some kind of, then extend your protection. And another thing, I look into the Nigerian system, the Nigerian, when you look into the Nigerian patent or intellectual property rights framework, you see that if I want to check the status of a trademark in Ireland, for example, all I need to do is to to the database and just search it up. I know when it was registered, I know when it's going to be renewed and things like that. So that's giving information to SMEs, telling them that, okay, this is what is available and this is what you can use. And I try to do that for the Nigerian space, and it's very, very difficult to actually get an online patent register in Nigeria. And that's not a good look for SMEs, because you don't want to expend so much money conducting searches and waiting so much for your search result to come. You want to be able to make those decisions, and having a digitized trademark register is very, very important. And one more thing, because I research on technology transfer. So SMEs are very, very, for you as an SME to actually capture, to know what to do. A form of technology transfer is looking into expired, looking into patent applications. Patent applications will tell you that, yeah, this is the way this thing was done, and this is the kind of invention that was created with this patent application. When those things expire, you can take them, look into them, there are a lot of things that you can do with expired patent, with expired patent applications, with the kind of information you have, the kind of technical information you have in those patent applications are very, very important to actually encouraging innovation. So those are one of the things that PIPO should be looking into, creating a central and accessible depository for patent applications and specifications, so that SMEs can actually go into those spaces. I know that WIPO has patent scope and all of that, and you can use patent scope. But in the context of Nigeria, for example, I want to be able to go into the patent office website. I want to be able to see that, okay, what patent applications have expired? What can I do with this information, with this technical information? How can I invent around these patents? So patent applications are important for technology transfer, for technological knowing, for building technological expertise. And I think the Nigerian Patent Office should invest more in creating a central database that SMEs can actually look into and extract information they have, so that we can start building our own local and viable technological base in Nigeria. So the FCTA will do it. It will open up different markets for us. The problem is, are we even in a good position to take advantage of the new market? For us to take advantage of the new market, we have to go back to our intellectual property framework. We have to ask ourselves questions. Are we able to encourage innovation with the kind of intellectual property rights framework we have? Do we have the right legal infrastructure to ensure that these things that intellectual property are protected and enforceable, so that when we protect our interests at home, then we can look at conquering other jurisdictions. But the work is still there for the AFCT. It's still at the very, very initial stage, but it's going to be a very, very important tool to spread technology transfer within the African region, to build local innovation, to do, the possibilities are endless for the AFCT and the IP protocol. But I just hope be able to, in the Nigerian context, we'll be able to provide the kind of incentives to take advantage of these new markets. Sorry.
Thank you very much, Ope. That was very enlightening and insightful presentation. While we have questions, I will jump over to Rita quickly, but I'll come back because we have some people have special questions. Let me jump to Eric quickly. Eric, based on we've been in Africa here, what would you say is the interplay between IP and technology in helping maybe African SMEs maybe scale and gain market share in other jurisdictions like the Americas and also in Europe? What would you say would be the interplay between IP and technology, yes, and what would be the strategy that they should use in trying to gain market share and taking their products to the market in other jurisdictions outside Africa?
Okay, thank you, and apologies for the previous time. So,
was that to me or to Rita? Sorry.
It was you.
Okay.
Eric.
Okay. Actually, I would defer to Rita, because I'm, know very little about IP protection specifically in Africa. And I think what OPME's presentation was fascinating, and the discussion of the role of governments and the reason we have IP laws to create incentives was tremendously important. And yeah, so I don't know that I have a lot specifically to add to address your question. I apologize.
So what advice would you have for startups SMEs trying to come into your markets to play in your market, since you have an experience in your market? So in terms of the IP and IT interplay in that sector, they are coming to your market. So it's actually you're the expert in that area.
Okay.
So what strategy do you think they should have trying to gain market share in your jurisdiction, basically? Coming to them, for example, like a Nigerian startup coming to America, for example, to come try and gain market share and release products. So what advice would you have for them?
Yeah, and it's not very different from a startup within the U.S. The advice is very much overlapping in terms of reviewing all the different intellectual property protections that might be available, making sure the trademark and the brand name is available, because even if you're using a brand name in another country, coming to the US or coming to another market, you want to clear the brand name in those additional markets before you enter those markets. And sometimes brands have to change or tweak a brand name to enter a different market. And of course, reviewing what other protections might be available in terms of patent and other IP, and taking advantage of international filings, would be something to look into as well. We have many clients who take advantage of the Madrid Protocol and WIPO trademark filings. That makes it a little bit easier, a little bit less expensive, actually quite a bit easier and quite a bit less expensive to file trademark applications if a mark is already registered or pending in the business's home country, to then use the Madrid Protocol system to file in other jurisdictions that are members of the protocol much more smoothly and efficiently. There are some risks and downsides to doing that, but the trade-offs for the ease and for the lower expenses are generally worthwhile. So we always recommend clients, when entering new markets, to search there and to consider applying to register there as well. One particular market where we see this happening a lot now is China, and we actually are advising more and more clients to file in China as early as possible, as soon as they may grow to be an international business. They need to think about protecting in China because of the challenges that arise in China when someone else files before you. And we're finding more and more and more that that's becoming a problem, that people are filing in China when they seem to be researching other businesses that may be growing and then filing in China in order to block them, the actual owner, from filing in China.
Well, thank you very much for that. Rita, quick one from you. What novel or practical disputes resolution mechanisms would you say would be available to SMEs, basically avoid or to navigate IP conflicts that arise, especially when they're trying to gain market share and scale the market?
Okay, so first of all, I think we need to explore the option of having like an IP specialized court to handle IP disputes. In Nigeria here, all IP disputes are filed at the Federal High Court. I think once we do that, it will take the load or the burden of the judges in the courts. You need to also have trained experts that specialize in IP, be it the judges or the council. and also more on awareness. So you also have the option of resolving your dispute via arbitration or mediation or negotiating or exploring any of the hybrid form of ADR mechanism. I know about I think 2 or 3 years ago, 4 years ago, we had the case of the blackface against Two-Face, where Blackface has been accusing Two-Face of, stealing the song "You're My African Queen." They eventually settled out of court at Lagos Multi-Door Courthouse. So we're hoping to see more of this being resolved through ADR. We also have the white pole ADR mechanism, and then again, sometimes they need to also settle in court in order to set precedent. I know one of the most trending IP case in Nigeria this year is the Oluturi case, which is in court. We're hoping to get a judgment. Then you also have the RCCG case, where it was said the national praise team had used a gospel artist song. So we know that there are certain industries that we need to have precedents that will guide other people going forward, so that people will begin to appreciate IP, because IP is basically an investment, and most creatives and innovators within this jurisdiction don't even get enough benefits or make money from their content. So while we always advocate for ADR, there's a need to also explore litigation, IP dispute. Then again, there's a growing trend of social media collabs, which have worked for some people, where a designer or an IP owner will be calling out a potential infringer. I know there was a case this year about someone copying a comic story and converting it into a movie, word for word, not changing anything. We also had the case of Zara being called out for copying another smaller brand's design. Then you had the case of Gucci as well this year. I think that was last month. So while we want parties to settle, you also have to have this precedent. So everyone would be on guard. They also need collaborations from the enforcement agency. So you're talking from the immigration services to every other enforcement agency, where they have to work hand in hand with the IP owners and also the courts to ensure that infringements are not on the rise. Now you have more of digital infringement than manual infringements, because now it's easy to reproduce and distribute content online. So I think what we should work towards, first of all, is having an IP court, specialized IP court with specialized practitioners, training everyone, the judges, the lawyers, the registrars, everyone needs to be trained. Even the examiners at the patent and training offices need to be trained, so that they do a good job in giving us a name out there that our registrations are valid and not just a worthless paper at the end of the day. So those are my contributions.
Thank you very much, Rita. That was useful. Eric, there's a question here for you. I'm not sure if you've seen it under the Q&A section.
Yes. Yes, I was just typing a response, and the Google versus Oracle case is very interesting, and I have not had a chance, unfortunately, to fully unpack the recent decision from the U.S. Supreme Court. But for those unfamiliar with it, it relates to a large copyright dispute regarding Google's use of APIs that were developed by Oracle. And APIs are the way that my crude understanding, the way that different software programs sometimes can communicate with each other, right, and interact with each other and build from each other. And so the Supreme Court overturned the earlier decisions and found that Google was not infringing. And hopefully this will strike a balance between, as I put in the chat, will strike a balance between providing incentive to software developers to create works and to protect them and to own and control the copyright in them, while balancing that with an incentive for developers to work off of existing works and APIs to build new things. And I think that that's always the balance, going back to some of the policy issues that were discussed earlier. That's always the balance in how an intellectual property framework is built and used by the government and in operation in business, is to balance giving the creators and the businesses incentive to invest money and time so that they have some control and can profit for it, while keeping the ability for others to build things that, and create new things as well. And striking that balance is never easy. And we see from this Supreme Court case, that maybe it's always shifting a little bit, particularly with new technologies.
Okay, so I'd just like to add something to what Eric had said with regards to this case. So we know that IP is basically territorial, and then again, we have to look at the international aspects, especially when a dispute arises between two giant tech companies. Now, we know when it comes to software, software are more or less computer program, and a software can only be copied once. Save for when you have piracy, where people are able to, either find a way to break the codes and also reshare and keep resharing and resharing. Is it going to affect the global software sphere? I don't think so, because this is more of a US jurisdiction, except for when, let's say in Nigeria now, we have a similar case and the court decides to rely on the decision of the Supreme Court in the Google Oracle case. Then again, you also have to look at the principle of the fair. In Nigeria, we have the fair dealing principle, whereas for you had the opportunity to go through the job, and you see that what the court did was that they went through the 4 factors guiding the fair use principle as to how much was used. Was it for commercial purpose? Because you know that for developers, you have an open source code where it's easy for you to always copy and always update. And IP for patent, say you mention, then you become the new anything to and already exist to rely so much. Then the Google Oracle case initially was a patent dispute. However, it was dismissed at the initial stage of the trial, and then the parties basically just focused on the copyright angle instead of going more for the patent, because it's something basically, especially in the US and UK, enjoy protection under a patent, where you have to show the functionality of that software as to how the invention is going to work at the end of the day. But if you want to know more, I did a podcast recording with Standard on this case, and it was published this morning on Anchor. You can also listen to Eric and I recording. Did that last year on we did that last year on the road of trademark for SMEs. So yeah, you can just check out #IP series on Anchor or Spotify, Apple, Google Podcast. So and then you get the full download of what Google Oracle case lab. I hope I did answer your question, but if I didn't, you can also send me like a private message and talk further on the.
All right, thank you very much, Rita.
Just to add a little bit of it from the public policy perspective of IP. So, because when I was reading the judgment of the case, the court said that going back into the Constitution, the rationale for copyright protection is to guarantee some kind of social progress, to ensure that we begin to create new things. So the court argued that the kind of copying that Android or Google did on Oracle's code, they copied just 11,800 lines of code out of 1 million. The court said that that kind of copy was to create some kind of progress to shift to create some kind of progress in the software industry. Without copying those lines of code, we might not have been able to have an Android system that will be open to other creatives. So the court is looking at why was it copied? Was it what's it called, a form of balancing, like what's it called, the public interest. Was it for to extend the public? Was it in public interest, or was it just for commercial purposes? And for in the Google versus Oracle case, the court said that the rationale was to make some progress in software development, and that was the reason why the court was saying that yes, like although there was some copying, but using the what's it called, the fair use doctrine, that it was not it was not an infringement. So like software development should give you the idea that if the software, if you're copying another person's software, although that would be for your lawyer to advise you, but then, well, if you're copying your software, the court will be looking at balancing that interest, whether it's in the public interest, whether it was just for you, whether it's just plain stealing from another person, or maybe there's a public policy rationale behind it. Thank you. Why is it?
Okay, thank you for that. You have two questions here that was directed to you, one by Vivian, one by Jibola.
Yeah.
One says, can you please speak to the exceptions of the TRIP agreement when considering as a case study? So if you could run through the two questions very quickly, give them short, concise answers, that would be good.
There are few exceptions in the TRIPS agreement, depending on the country. For pharmaceuticals, for example, you have what's it called, Article 31. Then Article 31 talks about compulsory licensing. Article 31 BIS talks about compulsory licensing for pharmaceuticals. So those exceptions are there in the letters of the law. Like even if you look at Article 7 and 8 of the TRIPS agreement, they talk about that the TRIPS agreement should be interpreted like the TRIPS agreement does not actually block the ability of countries to exploit their own national policy space. So what our country will need to do is the way we interpret the obligations. So you can interpret your patentability criteria. You can interpret it widely or narrowly, just to ensure that you create some kind of, you insulate your domestic or innovation system. So it's like what they do in India, for example. India interprets its patent system broadly, just to ensure that foreign companies do not capture their innovation space. So Nigeria, it's left to interpretation. Actually, the letters of the laws are there. It's just for us to interpret it broadly and then design our patent law. Like what we have done up till now is just like copy and paste. We've not actually sat down, have a conversation about what kind of innovations thrive in Nigeria, what kind of incentives would be important to drive innovation in Nigeria, and how can we bring that within the letters of our international obligations. We have not done that. Basically, what we have is just the UK law removes some things and then turn into a Nigerian law. So there needs to be some kind of purpose. There needs to be some kind of purpose behind lawmaking in Nigeria. It's not just about seeing that India is doing something, for example, or the UK is doing something that we copy it. Although laws we can't really transpose law, because law removed from the context is just words. So you have to look into what works in Nigeria, what can work in Nigeria, what will incentivize or innovation in Nigeria. So those are the things you have to look at. I think there's a second question there about, is it productive for a third country to strictly obey international? See, that is what I'm saying. Like, the exceptions are there, but you need creative lawmaking. We need a legislative arm that is actually creative in carving out those little exceptions, those little spaces for like policy spaces, because policy space is just an avenue for countries to define, to look for exceptions, to create their own policies that would support their own development. So it is for these international obligations are there China has international obligations under what's it called, under the TRIPS agreement. That has not stopped China from actually defining its own intellectual property framework to suit its own development. India also, they have WTO obligations. They have obligations under the TRIPS agreement, but they have a very, very robust pharmaceutical industry, and that goes to creative legal drafting, creative legal a creative legislature. It's not just about copying and pasting. So our legislature, we have work to do. We have work to do just to have a national conversation on how we want to develop, what we want to develop, how we want to fund research and development, if we want to invest in universities, and if universities will have to transfer their technology to public space and then let the state commercial. So there are a lot of things to do. It's not just about the kind of laws we have. So there's a lot of background work that we have to do in framing our laws, and we haven't done that up till now. So all we have in our intellectual property framework are old laws, or laws that are not like actually gets to our own development agenda. So that's one of the problems we have in Nigeria.
Okay, I think I'll just say something with regards to the question by Achibola. So it's not like it's strictly or we're mandated to obey international IP regimes. You only do that when you're signatory to those treaties. And if you know, Nigeria is not signatory to the Madrid Protocol, which is for trademark. Another thing is that most of these treaties were created to attend to issues that involve or within the developed countries. We don't have treaties that tackle or try to solve the issues we have within our environment. So there's a need for us to create like an African international IP standard, whereby whatever treaty or laws we are creating would be able to take care of the issues within our environment, which is why the AFTA agreement is a good way to start. We just hope that with the view of having access to the 1 billion single market, other issues around not having a harmonized IP law would not affect the progress of it, because where you don't have a harmonized law, it sort of affects the development because each of these countries are at different level of development. So we have to have like a general contribution from all the 55 countries, African countries, also set an African IP standard for us as to what actually qualifies as IP. Because we've seen instances where people or countries, developed first world countries, will come into an African country, take something of them, and then go and reproduce it and then patent it or trademark. So you've seen cases around the plant varieties, geographical indications. I know there was one about the Ethiopia coffee that took a long while. Then there's another case about the green, I think it's the green red bean, something like that. That has to do with plant variety. So we have a lot to do. Yeah, we don't have a comprehensive IP law. We have a lot to do in terms of setting our own IP standard. We have to do that in one voice. And because we don't have a strong IP law, it's easy for anyone to just come in, take and steal our product. So someone said something the other day, the hen's jollof. What's the reason behind that? We know that jollof is more of like an African dish that is, Nigeria has their own version, Ghana has their own version, but then hens has gone along to create like a jollof spice. And what's the purpose of that? At the end of the day, it's just to make it generic, whereby if we eventually decide to say, okay, let's take advantage of this and, link it to Africa, then it becomes difficult for us to even enjoy protection or take advantage of the economic benefit internationally. Our copyright law is not only focused on music. So if you read the copyright law, Section 1 lists all the eligible works that enjoy copyright protection. And copyrighted works actually gives you an automatic protection so far as that work is in a fixed video. However, in the event of a dispute, it's advised that you deposit a copy with your national copyright office so that you get to have like the upper hand in the event of a dispute. And documentation also helps you in when it has to do with IP ownership or authorship. What else? What else? And yeah, we have our copyright bill at the House of Assembly, and it's not been passed since 2015. And I hear there's a trademark bill as well. So there are a lot of bills out there, but no one is lobbying for it to be updated. We're just sitting and waiting. So what IP practitioners basically do is whatever IP trend is out there, we try to domesticate it and look at it from the Nigerian perspective as to what would we would do if in the event that this dispute was within our sector. I hope that answered your question, but if it didn't, you can always send me.
All right, thank you, Rita. Okay, so next question: why is a patent the best way for ingenuity in Africa? Why not prize money, given Africa's slow pace of development? Could you quickly take that as a roundup?
It's not really a legal question, it's more like an economic question. Like, how do you quantify the right price? So, like, giving a patent is outsourcing the reward for intellectual property. You let the market decide. So the fact that you have a patent does not actually guarantee that you're going to make money off it. So then the question is, who do we like? There are different innovations coming up every day. Who determines what the right price is? How do you get the connection between the what's it called? Or for example, how do you give a price to someone do you give the same price to someone who has developed the vaccine for coronavirus and the same person who has developed how to make air fryer? So there are two different things. So when we have the patent system is a democratic system, basically, just you give them the right, then let the market decide. But because if you have a patent in air fryer, the market will decide whether they want to pay top dollar for your air fryer or not. But then when we have a price system, then everybody has a right to a price, which is not sustainable. So there are different arguments. There are some people, there are different arguments on this thing. Some people even argue that there's no reason to actually reward anybody for it. The guy that developed what's it called, penicillin and insulin, they didn't seek for patent protection, and that's their choice. But to continue to fuel innovation, you have to give something. Patent is not like it has its own problems, but how do you decide what price, what's the right price? How do you determine who to give the price? Do you get? So a patent will give you your exclusive right, and you go to the market. If the market is willing to pay top dollar for it, yes. If they are not, fine. And that is why competition law develops on the side of what's it called, of intellectual property law, to ensure that even if we give you this protection, if you try to abuse it, then the competition law part comes into play. So it is synergy. It's about it's creating a synergy between IP and competition. That's how you protect the public from unscrupulous elements who might want to use the patents in the patent system to game the public. So patents might not be the best. We might have our reservation about patents, but then at the end of the day, like using prize money, how much do you want to give?
Okay, thank you very much. So Eric, any final words before we close based on the topic? Any final word?
Fascinating discussion. I've learned a lot today, so thank you for including me on the panel. And just to come back to the broad topic for today, taking your ideas to market, there's obviously a lot of different considerations for small businesses, depending on what their market is, where their market is, how quickly they expect that it might grow. But one thing we can all agree on is that thinking about all of this intellectual property from the start is the key to helping become a protected and successful small business. And in particular, small businesses are such an important part of every economy. LBM had some statistics on that in his presentation that I really enjoyed. And big companies make so many of the headlines here in the US, Amazon, Apple, Google, things like that. But it really is, in my neighborhood out here, the local hardware store, the local restaurants, the local coffee shop, and the small businesses, and even local factories and local service providers, real estate agents, accountants, lawyers, that really are the heart of the economies and so important. And the more of them that protect the intellectual property, the better the system will be for everybody.
Thank you. How about you in the final word?
Yes, I do. So my final word would be that before you take your idea to the market, first of all, you need to do a lot of documentation, be it your contracts, IP ownership, and authorship. Then you also need to consider registering your IP, very important, especially within the territory or jurisdiction that you wish to expand or grow or do your business. Then you also need to see IP as an investment, a long-term investment. Like Eric had pointed out, the bigger brands are the ones that have been there for ages, and they employ or exploit a lot of aggressive IP marketing and monitoring, whereby the moment they see any small brand doing something similar to what they're doing, they're already sending a cease and desist letter. And then we saw that good in the Haribo case. I'll keep really guided as to the right protection is best and key. And let's keep advocating and creating awareness on IP. Thank you.
Thank you. Ope, in final word?
Yes. Just remember that your intellectual property is just treat it like an asset you have, like your house, your machine. So you have to guard it, you have to protect it with all you have, and the infrastructures are there. Although the infrastructure the legal infrastructures, they might not be perfect, but then seek them first and seek the kind of protection you want first and build from there. And then but the what's it called? At the end of the day, the most important thing is for Africa to actually get to where it wants. We have the 2063 Africa we want agenda. For us to get to where we want, we're at a critical juncture where we have to design an intellectual property framework that will actually create that future that we want. So it's a very, very important period in our in the development and in the life of the African continent. And I hope that we'll make the right decision. We implement the right policy to actually engineer the kind of future we want. So, but your IP is your property, is your It's very, very important. You're creating it with your mind. So guard it with all you have. Thank you.
Thank you very much. Thank you very much, all. Abigail?
Yes, hello. So thank you, Eric, thank you, Rita, thank you, Opemi, for taking time out of your busy schedules to be here. This was such an insightful session. I've definitely learned a lot. Also, thank you to the Intellectual Property Society of Nigeria, to Tech Hive Advisory, Garnet Law Practice, and Legally Plugged. And also thank you to all the participants for joining in. I'm really sure, and I hope and I'm sure that you've learned something from this session. So once again, thank you everybody, and have a great day.
All right then, thank you guys.
Thank you, Rita. Thank you.
Thank you, Abigail. Thank you, DJ. Eric, thank you. Fayemi, thank you.
Nice. Okay.
Okay.